Welcome everyone who's joined us so far, and welcome to those who haven't joined us so far, even though you can't hear me saying this. Welcome to the latest In-House in Focus seminar, the Start of our autumn programme. I've got the easy job today of merely hosting this. My colleague Alex is going to talk to us about return on investment on IP enforcement activity, which I'm sure you'll all find interesting and stimulating. Just a couple of housekeeping points as a prelude. We are recording this, so if you're so enthused by it and you want to watch it again, it will be available. Anyone who wasn't able to join us live and is watching the recording, welcome retrospectively, if that's the right word. You're obviously linked onto the recording, and I think the handout will be available to those who want it. We will do questions at the end of the session, not as we go along. So please, if you do have anything to ask of Alex, stick it in the Q&A box at the bottom of the screen. I don't know if chat appears for you as attendees, but don't put it in chat. If it does, please put it in Q&A. And a couple of points, if you can reference the slide that's being talked about on your question, in case you're at the end of the seminar, your question it doesn't make sense without knowing which slide you're talking about. That would be really helpful. And if you feel comfortable, please don't be anonymous if you're asking a question. I only say this because if we don't have time to get round to answering your questions, we would want to follow up on it afterwards. And if you are just down as anon, we won't know who to respond to. So if you could do that, that would be tremendous. Ignore the box about poll questions. I don't think we've got any poll questions today. And at the end of the seminar, there will be an opportunity to fill in feedback. Please do spend a minute or two doing that if you can. The main reason being not just we want to know how we did, though we do, but we want to know what you want to hear about for future seminars. This is your chance to let us know what topics you want us to cover in this program. So that's the housekeeping. Any fire alarm you hear is entirely your business, nothing to do with us. So I'll hand over now to Alex to tell us all about it. Alex.
Thank you very much, Simon, and welcome everyone. Thanks for joining. So yes, I'm going to talk today about return on investment on IP enforcement activity. I'm going to focus on the commercial and strategic considerations pertinent to any decision a business makes to engage on that sort of activity. There's going to be very little law in today's session. Some of you may be pleased to hear, some of you maybe less so, but very little law. What I am going to talk about is not going to appear probably as I go through and as you leave this session massively new, insightful. You'll probably leave this session thinking, well, that was all common sense and obvious. And I would agree with you. The reason I'm going to dwell on stuff that seems like it's common sense and it's obvious is because in my experience in the last 20, 25 years of working on IP enforcement activity, there's been many, many occasions when the stuff I'm going to talk about hasn't been front and center, either at the start, the middle, or the end. To a sufficient degree, in my view, businesses tend to lose sight of why they started on IP enforcement activity somewhere along the way, or weren't entirely clear about why they were engaging on it in the first place. So, yeah, please forgive me if it seems obvious, but hopefully it's valuable nonetheless. So, when I came to think about how to deliver this session today, I thought about how to structure it. It wasn't the easiest task because there are a number of reasons why businesses might engage in IP enforcement activity. There are a number of different ways in which they might go about it, the way they approach that type of activity, and the outcomes of the actions which people take can vary massively. So, and often those outcomes are very difficult to value, because there isn't a direct, obvious pound value to put on them. So the way I decided to approach it was, we'll start with the why. Why do businesses engage? Some of the reasons. We're going to look at how businesses engage in this type of activity. We'll look at the what. So what is IP enforcement activity worth potentially? And the flip side of that, the downside of it, what does it cost? And then we'll finish off by looking at some things to think about, some of the strategic considerations in a bit more detail, and some of the key takeaways from my perspective. So why engage in IP enforcement activity? Well, the first and most obvious reason typically is to stop unfair competition. Intellectual property rights, at their core, are rights to prevent unauthorized parties from exploiting intellectual property assets without consent. They confer a right to stop that unfair, unauthorized competition. And in an awful lot of cases, the desire to prevent that unfair competition is at the heart of the reasoning why a business will decide to take IP enforcement activity or contemplate IP enforcement activity. That much, as I said, obvious. Another reason, and again, it's an obvious reason, is that when businesses see their intellectual property assets being infringed, they want to be paid for it. They don't want their infringer to get away scot-free. They've invested in developing intellectual property assets. Anybody else using it without authority should be held to account and required to pay. So that's often a reason which businesses will bear in mind, and it will often be pretty much front and centre. I'll come on to talk about how sensible it is to put the pound value of the dispute and enforcement activity at the centre of your thinking. Another reason, a business may very well want to send a message. Obviously, it may want to send a message to the particular competitor or infringer to warn them off doing it again. But there are other types of business or party who it might be wise to send a message to, and we'll come on to look at that. And then finally, quite often, particularly in the first conversation I have with an IP owner who is contemplating IP enforcement activity, the first thing they're thinking about is that as a point of principle, it's not right that their intellectual property rights are being infringed and they want to do something about it. And quite often the point of principle is there at the front of the thinking and has blurred, if you like, or obscured some of the more kind of incisive commercial reasons why taking action might be appropriate. So how do businesses typically approach IP enforcement activity? Couple of ways it can play out. The first and obvious one, and the most usual one, I'd suggest, is the out and out adversarial approach. So private practice lawyers, in-house lawyers will know that when their stakeholders, when their clients come to them and say, there is somebody out there who is infringing our intellectual property rights, the first thing they're asking about is sending out cease and desist letters threatening all hellfire and damnation if the business in question doesn't cease and desist from the infringement. Minds are already very much on litigation. Minds are potentially on interim injunction applications. Interim injunction applications come up very often. There seems to be still a view within businesses generally that interim injunctions are remedies which are quick and relatively easy to obtain. That is a fallacy. It has been a fallacy for as long as I've been practicing in intellectual property law. I would suggest that in 99% of cases where somebody suggested to me that they want an interim injunction application hasn't been made for various reasons. Generally, people are talked down from that for reasons I'll come on to. But nonetheless, litigation is very much front and centre typically of people's thinking. People are thinking about trial, they're thinking potentially about appeals if things go wrong, and really getting ahead of themselves. We'll come on to talk about whether that is the right mindset. You can probably anticipate what I'm going to say about that. There are alternatives, obviously, to that out-and-out adversarial litigation approach. These days, a lot of infringements take place on retail platforms. So you'll see the likes of Amazon, eBay, Etsy. A lot of traders on these platforms will, whether deliberately or inadvertently, be listing products which infringe the intellectual property rights of others, or there'll be something about the listing itself, the content of the listing, which will infringe the intellectual property rights of others. And these platform rules these days will have their own contractual IP protection policies, which everybody who operates on the platform will need to sign up to. And it basically gives the platform carte blanche if they receive a complaint of intellectual property infringement to be able to suspend the allegedly infringing listing. And as an IP owner, that can be a real benefit because it gives a quite quick and easy way to deal with an infringement. the rules and the law in relation to that have changed slightly. It used to be regarded that taking the platform rules approach was pretty much risk-free from an IP owner's perspective. You could make your complaint to a platform, expect that the listing that you were complaining about would be taken down, and not necessarily face any comeback. The law has changed slightly in relation to that, so there is some risk associated with making groundless threats or ill thought through complaints to platforms, but nevertheless it's still part of the arsenal of the adversarial approach. And the final, and I guess most nuclear option, is criminal law enforcement options. The infringement of many intellectual property rights is a criminal offence, and depending on the perpetrator of the infringement, depending on what their objectives are, it may well be that criminal law enforcement is appropriate and the involvement of criminal law enforcement agencies is necessary. Those cases, as you would expect, are pretty rare. They tend to be reserved for out-and-out piracy and counterfeiting cases where the wrongdoers know that they're wrongdoers, and the issue isn't about establishing liability. The issue is more about pinning them down and enforcing rights and stopping them doing what they're doing. It is a relevant thing to consider, but in the vast majority of cases, criminal law enforcement isn't going to be appropriate in typical commercial litigation type disputes. The alternative to the adversarial approach, the collaborative approach, and this is often something which businesses who are having their intellectual property rights infringed don't consider, certainly not at the early stages. And by this, I don't mean sending a Part 36 letter in the early stages, which is hugely passive aggressive and doesn't expect to get a very positive response. That's not particularly collaborative. I'm not talking about engaging in mediation activity alongside litigation, where the mediation tends to be an opportunity for the parties to score points off each other when nobody really expects to settle. I'm talking about genuine attempts at collaboration. Now, there are often situations where intellectual property rights are infringed, but they're infringed by infringers who aren't competing with the intellectual property rights owner. The intellectual property rights in question may be being used in an unauthorized context in non-competing applications. It may be that an infringer is finding opportunities in markets which aren't available to the intellectual property owner. In those circumstances, there may very well be a licensing opportunity there, a commercial opportunity, and a potential dispute can be converted into a commercial arrangement. Licensing opportunities are an obvious option in those circumstances, but going beyond that into true collaboration and joint ventures, if everybody keeps their tempers in check and is able to see beyond the red mist of the unfair infringement and think, actually, what can we get out of that? There are very often opportunities for businesses to work together. Yes, obviously, trust needs to be established and built, but it may very well be that an infringer might have access to resources, to technologies, to partners, to markets, which the intellectual property owner doesn't have access to, and working together to exploit the intellectual property in a manner which is similar to or developed from the manner in which the infringer is exploiting that IP could be a sensible way forward. So it's always worth thinking about, try to park the red mist and think, is there an opportunity here, as opposed to an out-and-out dispute? So what is it worth to stop the unfair competition associated with intellectual property infringement? This is a question which I'm asking at the moment in the context of that internal discussion within the business, within the stakeholders. I'm not thinking now about what can we convince a judge that our loss is, thinking ahead towards damages. I'm thinking internally, can we justify it to ourselves that we are taking some sort of intellectual property enforcement action? And if so, how far can we go and what can we justify? And there are a number of ways that you can try to assess what unfair competition is really costing the business. The obvious example where a competitor is infringing in circumstances where there's a threat of lost sales to the IP owner is, have a think about to what extent have sales been diminished or are they under threat as a result of the infringer's activities? And what are the lost profits associated with those lost sales? Another issue that businesses should very much bear in mind is the dilution issue. So in the context of trademarks, that's fairly easy to understand conceptually. If a brand is being infringed by whether it's a lookalike brand or something which is very similar, a lot of the brand equity which has been built over the years in that brand, in the probably a registered trademark, can be put under threat because the market starts getting either confused potentially, but at the very least they stop seeing the premiumization associated with the IP owner's brand, and allowing the brand to be infringed can undo a lot of the value associated with that brand, which has been built over a number of years. There's obviously also the issue of price suppression. That it may not be that a competitor is taking sales away directly, but it may be that the intellectual property rights owner needs to lower its own prices to consent compete rather with the infringer. And there is a value associated with that. It's not necessarily easy to put a value on, but these are the types of considerations which intellectual property rights owners should be bearing in mind when deciding, what is this costing me? What is this infringement costing me? And the last two bullets there, quantification to the extent you can you put a number on it? You'll never be able to put an exact number on it, but if you can come up with a ballpark and you can go to stakeholders within the business and say, look, we think it's costing us X to Y for the following reasons, that may give justification for the type of action that you're contemplating, and you may get signed up for it. The second, the most obvious remedy associated with intellectual property infringement is, what is the money going to be? The financial remedy which is attainable from the infringer, whether that be in the context of a settlement or whether it ultimately be determined by a judge. This is the first time that I'm going to actually talk about any law, first and last time. So there are a couple of recent cases in relation to damages which are important and insightful and eye-opening in my view. First thing I'll say about damages is there are very few cases in which the financial remedy in damages associated with pursuing a claim will be more than the cost of pursuing a claim all the way through to trial. So if the primary remedy which a business is looking to achieve by its intellectual property enforcement action is damages, then it's very likely to be the best plan to try and do a quick and dirty deal which may not deliver and probably won't deliver all the damages to which you might ultimately be entitled if you went to trial, but will still leave you with a much better net financial outcome than going to trial, spending a load of money that you're not going to get back, and then finding that the damages at the end of it aren't what you expected them to be. So Opoly and Gymshark, I'll start with Opoly. Opoly was an unregistered design right infringement claim where the defendant was found liable for having infringed multiple garment designs and sold, I think, about 15,000 garments. In the end, it was determined had been sold, which infringed the unregistered design rights of the design rights owner. And there then very rarely came to be a trial on quantum, because in intellectual property cases, what typically happens, and it's probably happens in 99% of cases, is that liability will be established first, and only if liability has been established will there be court proceedings to determine what the financial remedy should be for the claimant. And liability had been established in this case, and rather than settle the damages element, the quantum element, which typically happens and most often happens, the protagonists in Opoly decided to go to trial and have it determined by a judge. And the reason this case is particularly interesting is because of what was discussed and what was awarded in terms of additional damages. So damages are typically divided between standard damages, which are compensation for loss of profits on lost sales, and then in respect of an infringer's infringing sales which didn't result in sales lost to the rights owner. So the rights owner wouldn't have made those sales itself. The rights owner is still entitled to a reasonable royalty in relation to the exploitation in the intellectual property asset, on those sales the infringers made, which wouldn't have been made by the claimant. So standard damages, lost profits, and a reasonable royalty. And then additional damages are flagrancy damages, where the infringers, the circumstances associated with the infringement are so flagrant that it is justifiable to award additional damages as a deterrent to prevent that sort of thing from happening again. I know Polly was particularly interesting because in that case, the judge decided that 20% of the sales reflected sales lost to the claimant and awarded damages associated with that at, I believe, £75,000. The reasonable royalty which was awarded in relation to sales which hadn't been sales lost to the claimant, but which it was entitled to a royalty on, the judge awarded a 10% royalty on those sales, and again that was £75,000 or £150,000 in total. And then when it came to additional damages, which was a particularly interesting point, the judge went through all of the recent cases where additional damages have been awarded. And typically what happens is that additional damages are awarded as a percentage of the standard damages. So the judge might say, well, I've awarded you £150,000 in standard damages, and I'm going to give you a 10% uplift in additional damages for the flagrancy of the infringement. And what's interesting in the judgment in that case is the judge went through the recent cases, and the range of uplift percentages in those recent cases was absolutely massive. It varied from 10% to 2,000%. So there was one case in which the additional damages for flagrancy were 20 times the standard damages. In O'Poly, the judge ordered a 200% uplift, raising the damages from 150,000 to 450,000. Now that is good news from an IP rights owner's perspective, because it demonstrates, contrary to I think probably what a lot of practitioners have thought for a long time, additional damages aren't just a throwaway add-in, let's hope we get something more for it. They are a genuine head of damage which can deliver some significant financial remedy. And that creates significant risk for the infringer. The flip side is the Gymshark case. This was a trademark infringement case, out and out obvious infringement where the defendant was using, or the infringer was using, the Gymshark trademark in its Instagram post to advertise its own products, which had nothing to do with Gymshark's products. And Gymshark is a sports clothing brand. So the infringer had used hashtag Gymshark in the adverts for 70 odd Instagram adverts, and have been doing this for a number of years. Now this case isn't reported, but there is some information in the public domain about it, which I assume has been put in the public domain by those who are involved in the case. And the difficulty in that case was that although liability for trademark infringement was clear, assessing the loss to Gymshark as the claimant, which had resulted from the infringing use of its trademark to help advertise in this context, in the context of Instagram posts, it's actually really, really difficult. Because how can you demonstrate what the loss has been? And the way the judge ended up doing it, after hearing submissions on various different approaches which might be appropriate, was that he looked at the number of users who had clicked through the adverts to the infringer's website from these infringing posts and actually bought products as a result of clicking through from an infringing post which included the Gymshark trademark in it. And in that case, the damages were awarded, and bear in mind that this is across 78 adverts for a number of years, £2,000 in damages. Now, why am I telling you about these cases? As I mentioned at the start, damages are rarely going to be a huge remedy. There are circumstances where infringement claims justify going to trial, appeal upon appeal upon appeal, because the money aspect of it is very significant indeed. In the majority of cases, that isn't the case, and damages are going to be uncertain. And it's a double-edged sword, because that uncertainty creates risk. It creates risk for the claimant, but it also creates risk for the defendant. So what those cases tell us is that the sensible way forward is to try to do a deal, and I'll come on to talk about perception of risk, but use the uncertainty to get the best settlement deal possible. The second head of financial damages people talk about are an account of profits. Now, account of profits the infringer's profits attributable to the infringing conduct is available to a successful claimant as an alternative to damages. Very, very few claimants will ever opt for an account of the infringer's profits, because the infringer will almost invariably be able to demonstrate that it has made no profits associated with the infringement in question. So in 20 odd years of practicing, I can probably remember a couple of times where looking at the infringer's account of profits has been a viable option for one of our clients. Another aspect to consider when deciding what is the value of enforcement activity: sending a message. Now, I talked about sending a message to the competitor who has infringed the right. Of course, it makes sense to send a message to that competitor: we're not going to let you get away with this, don't do it again. But there are other types of business which you might want to be sending a message to. And I'm thinking in these circumstances about investors in the business, lenders in the business. If you are an IP asset heavy business and you have raised money or attracted investment on the back of the value or perceived value in your intellectual property assets, but you don't take any action against the infringers of those intellectual property rights, people who are using those intellectual property assets without consent, what does that tell your investors? What does it tell your lenders? What does it tell potential purchasers in a contemplated exit scenario about the real value of your IP if you're not willing to do anything to stop the infringement? So always bear in mind what message could be sent to the wider audience, not just infringers and other competitors. Is there value in sending a very clear message about the attitude which this business takes towards the enforcement of its intellectual property rights? And actually what can be really useful is if there is a particular competitor who, the relationship isn't great with them, and there is a suspicion that maybe they are looking at exploiting your business's intellectual property assets without consent, actually going after them on a relatively low value, simple intellectual property claim to make a point and let them know that you'll go hard on even the small issues might be a quick and cheap way of putting them off infringing in a much bigger and more valuable context. So that's worth considering. The final point of principle I mentioned at the start, businesses often come all guns blazing, wanting to sue, leave no stone unturned, get an interim injunction, and then realize pretty quickly that trying to make a point of principle isn't a very sensible approach and isn't a very commercial approach. But I often get the sense that businesses are starting with genuinely the point of principle front and center, and then looking for other reasons to justify the action they still really want to take as a point of principle. I just try and park the point of principle. It very rarely is a sensible basis for starting or sustaining any kind of IP enforcement activity. There should be one of those other advantages, whether it's stopping unfair competition, whether it's the financial remedy, whether it's sending the right kind of message, which should govern decision making in this context. And obviously, you look at the potential value of intellectual property enforcement activity, but you've also got to consider the cost and do the balancing act. So what is the cost? The first bucket of cost is obvious. It's your own legal costs. I always get really depressed when I get asked by clients, how much is it going to take me to take this to trial, when we're having the first conversation, because the vast majority of cases don't go to trial, and the numbers associated with taking an intellectual property infringement case to trial can be scary and eye-watering and put anybody off any kind of enforcement activity. But it doesn't need to be that way. Your own costs exposure in intellectual property claims, like other commercial disputes, at a certain stage of the dispute are going to be determined by how far you are willing to go and how much you're willing to invest and put at risk. That's obviously the case in the pre-action phase, before anybody has issued court proceedings and landed a claim form on the opponent's doormat. So you're in a position to decide, how much do I want to throw at this? It might be worth throwing £5,000 at. It might be worth throwing £50,000 at. I might decide ultimately this is worth throwing £500,000 at. But there is a choice there, and you can go a long way with an investment of £5,000. I'd suggest that in probably 90% of cases we deal with, the investment required to make an issue go away or resolve it probably is put at between £5,000 and £10,000. It's pretty rare that a decision is made which is justifiable to invest more than that, and where £5,000 to £10,000 hasn't been sufficient to make the issue go away. Obviously, the complexity of the legal and factual issues associated with the claim can add to the costs, and particularly complex claims are going to cost more than simple claims. Third point there I've got on the slide: what is the investment necessary to compete? And this is about thinking about your opponent. Are they the sort of opponent which has very deep pockets and they are going to throw every resource at defending the claim? They're going to take a scorched earth approach. They're going to tie you up in endless correspondence, take every point. It's true that court civil procedure rules are supposed to be designed to prevent that, but are they very effective at preventing that? Typically no. If the party is determined it's going to spend a fortune and drag you into the mire with it, it's going to do that. So think about the investment on your side which might be necessary to compete with your opponent. Maybe they've got very shallow pockets and are going to take the decision they don't want to invest very much. And if you know your opponent, you know your competitor, and you know that that's the type of business you're dealing with, then that's a relevant consideration to bear in mind when deciding what you're going to do. The middle point there on the slide: costs won't necessarily correlate to the value of the claim. That's because some cases genuinely are very valuable, worth a lot. The damages might be running into the millions potentially, but there might be actually quite simple claims when it comes to the legal and factual issues at stake. Other cases might be very low value, but have complex legal and factual issues associated with them. Gymshark's a case in point. Ultimately, damages awarded at £2,000. No doubt there was an injunction awarded in that case as well, which would have been valuable. But I don't know. I don't like to think about what the costs were associated with dealing with complex issues of quantum, trying to decide what the use of the #Gymshark infringing use of that trademark, how much that cost to the claimant, what their loss was associated with that use. The award was £2,000 in damages. I suspect that the costs associated with fighting it were many times more than that. Might be wrong because it's not reported, but I suspect that's the case. And the other thing to consider is the realistic cost recoverability. If you are going to get to a point where your proceedings can get into litigation, are you going to be able to recover your costs? And in some courts, cost recoverability isn't limited. You'll go through a cost budgeting process, but there isn't an upper level on the amount of costs you can recover if you're successful. In intellectual property claims, there are courts which you can choose to issue proceedings in where there are limits. So the Intellectual Property Enterprise Court has a £50,000 cap on cost recovery for the successful claimant or successful party at the liability stage, and £25,000 limits on cost recovery at the quantum phase. Think about, when assessing the likely cost of the contemplated action, what is the most appropriate forum? Is there a way of controlling the costs? Adverse cost exposure, it's always going to be a factor. As soon as you get to the point where proceedings have issued, any settlement of that claim, determination of that claim by the court, is going to result in the costs of both parties being dealt with in some way. And you very quickly find that costs become a significant aspect in any negotiation, and it's a significant aspect in the conduct of the litigation. And you may get to a point where you're at a progressed phase of litigation, and all the stuff that you originally started fighting about, you pretty much agreed terms for the settlement. The other side's agreed they're not going to carry on doing what they're doing. You might have agreed a figure that they should pay you in relation to the infringement, but then you come to decide who pays whose costs, or who might pay a contribution towards costs, and that can often be the most difficult aspect of the settlement, and the highest barrier to settlement. And partly that's due to the psychology associated with paying over some money as a contribution to costs, particularly if both parties feel like the outcome that has otherwise been negotiated is a win for them. If you think you've got to win on the other settlement terms, the likelihood is you're not going to be able to make the psychological leap to pay some cost to the other side unless you're able to park that psychological factor and take a purely commercial approach. And quite often it takes a long time to get there. The other element of cost, apart from the financial cost, is the risk associated with adverse judgment if you take something to trial and lose. So you're a claimant, you've taken intellectual property infringement action to trial and you've lost. Yes, you end up having to pay a contribution towards the other side's costs, but what are the wider repercussions? So there is a risk that you might have seen your registered right revoked. Invariably, particularly in patent litigation cases, the defendant will run a revocation argument as a counterclaim alongside its defence. It will say your registered right isn't valid, should never have been granted in the first place, and should be revoked. If you go to trial and a judge agrees with you and your patent is revoked, or maybe your registered trademark or registered design is revoked, then the wider significance of that to the wider market and other competitors who are otherwise deterred from infringement by seeing your right on the register, the benefits of having that right on the register can be lost. So that is a potential cost to consider. Slightly watered down from that is that it might be determined that the scope of protection afforded by your intellectual property rights isn't as wide as you thought it was. And you now have a judgment on the public record which says exactly how wide the judge thought the scope of that protection was. And it might give some of your competitors ideas that they can engineer around your protection or do some sail close to the wind and get away with it. So as I mentioned, loss of deterrent, encouragement of competitors and floodgates are a potential cost that you need to bear in mind. So some things to think about. I'll run through them briefly one by one. Enforcement doesn't have to be all or nothing. I've alluded to that as we've gone through the session today. I'll talk about it a bit more in a second. Can you minimize the downside, particularly associated with cost? Consider the timing of any action you're proposing to take. You don't have to do it straight off the bat. I'll come on to talk about that. Confront or collaborate, we've talked about. Another consideration, if you don't do anything, why did you invest in the generation of IP in the first place? There might be circumstances where you decide this, and the whole of this session is about trying to assess this. It is not appropriate in these circumstances for me to take action to enforce the IP because it's just not worth it. I'm not sustaining enough loss. My competitor isn't gaining enough. I should let it go because it's not worth the risk. But if that's the default position, it does raise the question, why do you bother investing in the creation of the IP in the first place? But I'll start with that first point. Enforcement doesn't have to be all or nothing. And again, I come back to this issue about not fixating on court proceedings, going to trial and incurring all of the associated costs exposure associated with that. And the vast majority of IP disputes do settle pre-action. If you look at the court records on a number of intellectual property infringement claims which are issued every year, they are dwindling. They've been dwindling for a number of years. You get some really big cases, you get big pharma cases, big telecoms cases, which are consistent year on year, big players, big money at stake. The lower value cases, fewer and fewer are issuing and going to court proceedings. And that's because, it's not because there are fewer disputes, it's because most of those disputes are settling at an early phase when the protagonists haven't had to invest in very significant amounts in legal costs. And the reason for that is because the risk cuts both ways, as I mentioned. As a claimant, considering whether or not to take enforcement activity, you go through that assessment. What's it worth to me potentially? What's it likely to cost to me? But your infringer, your defendant, potential defendant, has to be doing the same thing or should be doing the same thing. Try walking in their shoes. What buttons do you need to press? Who are you dealing with? Who are the individuals concerned? I'm slightly hesitant to talk about playing the man as well as the ball, but in any litigation, there are the merits of the claim on an objective basis, but there are also the people, the individuals, the businesses, the personal investment in the litigation which needs to take place. And all of that is a relevant consideration in deciding what to do. And how are the other side going to react? Are they at the deep-pocketed, cold-eyed multinational who are going to throw a load of money at it because they've already got the budget and they're going to wrap me up in litigation forever? Or am I dealing with a smaller business that wants to spend its time and its money on more productive things than intellectual property disputes. If it's the latter, it may well be that you can invest in enforcement activity and get a result quickly and cheaply. The perception of risk is one of the bullets there. People who have worked with me in the past will be sick to death of me banging on about the perception of risk. My view is that our job as lawyers, and particularly in the intellectual property context, is to do what we can to elevate the perception of risk in the eyes of our adversaries, because there are so many uncertainties associated with intellectual property disputes. The outcomes are uncertain in terms of will there be a finding of liability, but also the remedies. How much am I going to have to pay? How much can I recover? Elevating the perception of risk so that your adversary wants to do a deal quickly, but on terms which are as advantageous to you as possible, should be the focus at the start, not in most cases looking at interim injunction applications and litigation. Can you minimize the downside? As I mentioned, choice of forum is a really important consideration in this context. Is there insurance available to you which can help you hedge the risk associated with costs, your own costs and the other side's costs? Now, after the event, insurance in intellectual property cases is available, but very rarely happens because all of the variables associated with ATE insurance and intellectual property claims that doesn't quite fit the model for ATE. Before the event, insurance is definitely worth considering. This is where you invest in a policy before an intellectual property dispute has arisen. And in those circumstances, the premium is going to be very significantly lower and can provide a significant strategic advantage, actually, if you are able to tell your adversary early on in the proceedings, I've got insurance cover to cover the cost risk associated with this dispute. That is going to change their perception of risk associated with the whole dispute, because they know that you don't carry as much risk potentially as they do. I've mentioned funding, I mean third-party funding of litigation. Again, it's rare in intellectual property cases that this is a goer, but it can be, particularly in the valuable cases where the potential financial remedy is significant enough for a third-party funder to be interested to want a piece of the pie. Couple of sub-bullets there I've mentioned. Is this just the big cases? Typically, it only tends to happen with the really big cases, but it is possible to get stage funding from third-party funders for intellectual property litigation, where, for example, the pre-action phase of a dispute will be funded by a third-party funder in the hope and expectation that a deal will be done quickly with relatively modest spend before proceedings have been issued. It's worth thinking about. There are more and more providers of third-party funding who are willing to look at that sort of thing in an intellectual property dispute context. I'm coming towards the end, and I realise that I've taken up a lot of time, so I'll blaze through this as quickly as I can. Think about the timing when you're deciding what to do with your intellectual property enforcement activity. It's very tempting to go all guns blazing right at the start, banging out the cease and desist letters, potentially issuing proceedings. But in the early stages of an infringement, particularly where the infringer isn't a direct competitor and isn't costing any sales, it may well be worthwhile thinking about, well, okay, I'll put this business on notice of my rights. I'll tell them they've got to stop. But if they don't stop and continue to exploit my IP assets without my consent, and they do it to a significant degree, and they're making a shed load of money doing it, maybe I put them on notice of my rights, I reserve my rights, and then I sit back. And then maybe in 6 months, a year's time, maybe longer, I'll go back to them again. At that point, their exposure in relation to that claim is going to be significantly higher. The context will have changed completely from a potential settlement perspective. So have a think. Is it right for me to go in all guns blazing now? Or do I sit back, bide my time, and potentially wait for the damages pot to grow? Depends on the circumstances. I mentioned earlier, confront or collaborate. Again, particularly in non-competitive infringement scenarios, is there an opportunity to collaborate and make more out of the exploitation of these IP rights together than getting all adversarial, making enemies, which may stay enemies for years to come? And again, my final point there, if you're not going to do anything, and that's your golden rule, why invest in IP generation in the first place? It might be that you have a business model which is all about monetizing through licensing, and enforcement just isn't on your agenda. If that's the case, that's fine. If it's a properly informed, thought out strategy. But again, it's a worthwhile consideration, because if you're not willing to invest in enforcing it, it's difficult to see why others should invest in it. So some key takeaways. IP enforcement activity can cost too much. If you go to trial and then appeal to the Court of Appeal and then go to the Supreme Court, it's going to cost an arm and a leg, and there are going to be very few cases where that's justified. But in the vast majority of cases, as I said, court proceedings aren't necessary. The dispute will be resolved on terms which are acceptable to the IP rights owner before proceedings have been issued. Be strategic. What are you genuinely trying to achieve, and is it realistic? Don't go all guns blazing, throwing a load of money at interim injunction applications, which are likely to come back to bite you. Be creative. What is the best way to achieve your goals? Don't get stuck on that adversarial, we're going to sue them, litigation mindset, which puts you in danger of then getting stuck on what I call the litigation treadmill, where once court proceedings have been issued, everybody is so eager to make sure they comply with the procedural rules, they forget why they were really doing this in the first place. And then the procedural rules become the tail that wags the dog, and people lose sight of what they're doing it for. And again, I make this point about both playing the ball and playing the man. What matters to the other side? What buttons do you need to press to elevate the perception of risk on the other side? Make them think this needs to be settled, and it needs to be settled quickly, and make them realise that the risk is significant if they don't do that. So that's a quick canter through. Apologies, I've overrun by a few minutes. I'll hand over to Simon to see if any questions have come in.
Yeah, thank you very much, Alex. Because of the timing, I don't think we're going to have time to go through all the questions. So thank you very much for your two questions. I'm going to promise on Alex's behalf that he will respond to those and we will answer. We will maybe take the opportunity for those who can hang on for a minute just to answer a question from one anonymous attendee, since we won't be able to follow up with you. And this is an interesting question. Do you see different enforcement strategies or approaches in relation to different IP rights? I.e., do you tend to take a different approach for trademarks compared to copyright, compared to design right, or whatever it may be? What are the factors there, Alex?
So I would say that the nature of the intellectual property right is one of it's not high up on the list of factors that you bear in mind when deciding what the appropriate strategy is for enforcement. It will be the commercial context associated with a particular intellectual property right, with the nature of the infringing activity, with the scale of the infringing activity. People think, and it's a reasonable assumption to make, that when you talk about, for example, patent infringement, you're talking megabucks, and when maybe you talk about copyright infringement, you're not talking megabucks, and that the strategy for patent litigation would be a certain thing, and for copyright litigation would be another thing. Not necessarily the case. Now, there are patent infringement contexts where actually the value, the cost, all this kind of stuff I'm talking about militates against taking prolonged IP enforcement activity and in favour of trying to do a quick and dirty deal. There are other what appear to be very straightforward copyright infringement cases, for example, where there's been out and out infringement, you know what's happened, but it's happened on a scale in a commercial context where unraveling that can be very difficult from a defendant's perspective, because they might have invested in embedding the copyright asset in their wider operations. And that lends itself to a completely different strategic set of considerations than, for example, an infringement of a patent in relation to a standalone product, which would be discontinued in no time at all. So it really does depend on all of the commercial circumstances. And there isn't certainly isn't a one size fits all approach for any of those rights. You just look at, you deal with the hand you're dealt.
Yeah, fantastic. Thank you very much. Literally just popped up. If you could answer in one sentence, the answer is, I'm sure it depends, but is there a time window within which an IP holder might need to take enforcement action? I'm sure as soon as possible, and looking at any limitation periods, but what's the factor there?
So I can't do it in one sentence. I'll try and do it really quickly. A new cause of action essentially accrues every time an infringing action is taken. So for every single sale for example, of an infringing item, a new 6-year limitation period starts. So when there is ongoing infringement, that limitation period moves as the infringing activity continues. You cannot recover financial remedy more than 6 years after the specific infringing activity in question. So if sale 1 was 6 years ago and you've allowed that 6 years to elapse, you can't recover. But for the next 6 years worth of infringing activity, you can. That's one of the reasons why I said, is it worth biding the time? You may find that prolonged infringing activity leads to a damages pot building up, which changes the perception of risk and the parameters for settlement.
Fantastic. Well, thank you very much. We will knock it on the head there. I won't ask the question that I'd been thinking of about jurisdiction of defendants and enforceability of judgment. So you've ducked that one. Thank you, everyone who attended. Thank you, Alex, for the talk. That was tremendous. As I say, the link will come around at some point in terms of feedback on the talk, and this is your opportunity to let us know what you want to be covered in future in-house in focus sessions. So if you can spare the time, that would be really tremendous, because that enables us to tailor these to what people want. But as I say, thank you again for attending, and we will now wrap it up. Enjoy the rest of your day. Thank you.